Is it legal to record business calls or meetings?
Eesh.
Ooh, we want to know this.
Ouch.
Yeah.
Kind of scary. And sometimes you get lost in a heated conversation and you can feel like, I hope nobody recorded that afterwards, right?
Yeah.
Yeah. And sometimes you want it for evidence because you were angry. It can be your boss, whomever, right?
Of course.
Yeah. So, tricky territory. Some regions have one-party consent, like Sweden.
Okay, and that means...
That means that at least one party in the room needs to be fine. So I could record our conversation without you knowing it.
If you consent to it.
Yeah, but I cannot leave the room and record a conversation between you and your boyfriend. Because then nobody in the room has given consent.
Okay.
So I have to be in the meeting.
Okay.
Yeah. And other jurisdictions, like many in the US, many states, have all party consent. That means I cannot record it unless I tell you. So you also need to say okay.
Okay. Oh, that's really good to know.
I prefer the latter.
Yeah, you do?
Yeah. Because I think from an ethical perspective, maybe it's me as a lawyer, I don't think it's okay.
No, of course not.
I've been in many situations where it might help, but I wouldn't, never. I think you should let the other party know and ask them if it's okay.
Good. Then it's more equal conversation.
Yeah. And I think you should be very, very respectful for others' privacy. And also remember that when you have a meeting online today, often AI will record.
Like if you are on Teams or anything, for example.
Exactly.
Yeah.
So smartest for compliance and also for maintaining good relationships is to ask.
Yeah.
Start off the meeting. Is it okay if I use AI to take notes? So everybody knows. Then everybody has heard it.
So good.
Yeah.
So your suggestion would be ethical and inform everyone.
Yeah. So regardless of jurisdiction, then you are safe.
And now you also know about that. You heard it from the business lawyer. And remember, this is not legal advice. It's knowledge sharing.
Ask us your questions. We'll hit them straight on. We're in your corner.
We're in your corner. So just drop them down below. Until next time.
Hej då!
Hej då! How to get out of a contract without paying damages.
A question many want to know, given that we often are so fired up when we enter into that contract, right?
Yes.
So we don't mind that it's a 5-year period or we feel so good with this business partner.
Skip that part.
Yeah, all in. And then we wake up one morning and we feel that they are impossible to work with.
No.
Or I can't afford it.
Oh, it's
Right.
even worse.
Yeah.
And you already said yes and signed it.
Yeah.
So we're going to give you the most common mistakes today.
Yeah.
And we have the lawyer here, so make sure to buckle up and listen because this is a very important episode.
It is. And I would say number one, the most common mistake I see is where you actually have some legal ground for exiting. And we have a specific episode about legal grounds within the 4 corners of the agreement to exit. But you do not look at the notice period and how you are supposed to give notice.
Oh.
And what happens is that even though you were entitled to exit, terminate the agreement, perhaps you even have a right to claim damages from the other party. But if you do not adhere to the notice period and how to send that notice, and when we're talking about the notice, that is sending the message to the other party, then I want out, and I want out based on the termination period for 2 months, or because you did a material breach, because it's force majeure, because the conditions hasn't been met.
Okay, so the notice is when you let them know.
Yeah.
Okay.
And if you ignore that, you don't do it the right way, perhaps it says that it has to be in writing to a specific email address or even a physical address.
Oh.
And it has to be within 14 days of the breach or 14 days after you became aware of the breach.
Oh.
So if you send that notice 3 weeks after, or you send that notice to another mail, or you call them up, you haven't fulfilled your obligation, and then you have no ground to walk away.
Oopsie.
Oopsie.
So that's why you need to read it very carefully.
Very carefully. So common mistake number 1, not looking at the notice requirements and not following them. So very important.
Thank you. That's really good to know if we're listening to this. So let's move forward. The next one, common mistake.
And the next one will be just stop performing without having a reason, without having looked at those legal grounds.
Yeah.
Either within the agreement or some general principle that makes it so. Perhaps the requirement was that it was written, but you only have an oral agreement, you had to have witnesses, you didn't, etc. Or some consumer protection, something.
Yeah.
So you don't have a legal ground, you just stop performing because the other one is impossible to work with.
But you still need to stick to the agreement.
Yeah.
Yeah.
So if you stop performing, you will be at fault. No matter what the other person has done, if you haven't really looked at, do you have legal ground? Have I given notice? Then you're the one who will be paying damages.
And that is not good.
So hold your horses. Don't stop performing before you really checked the grounds. You document their potential breach and you give proper notice.
But you still need to be responsible for your part.
Yeah.
Good to know. So let's move forward to another mistake that's very common.
And another mistake that's very common will be calling everything force majeure.
Oh, well, you cannot do that?
No. Because force majeure might be a pandemic.
Yeah.
It might be COVID. So if you have the flu and you're out for 10 days, sorry, it doesn't cut it.
Does people actually do that?
Oh, yes.
Really?
Yes.
Oh.
But it's impossible. The price has gone up.
Just say force majeure and everything just stops.
Yeah. And there might be grounds to adjust the agreement, but it will not be force majeure just because you find it really, really hard to perform.
Oh, okay.
So remember, it's a high requirement to get there.
Yeah.
So don't call everything force majeure.
Okay, really good to know. And the next one.
And the last one, where you end up, even though you have a right to terminate the agreement, even you might even have a right to claim damages, is that you end up paying damages because you forget that even after the agreement is terminated, you will have obligations under the agreement.
Ooh.
There can be confidentiality. It can be assignment of intellectual property. Like who owns what can you do with it? It might be non-compete, non-solicitation. That is, you cannot go to those customers or those employees for a specific period. So remember that when you terminate the agreement, there can still be things that you need to do or not do.
Oh.
So that's a common mistake I see. You think that it's terminated. I'm done.
Yeah, I'm done.
Yeah.
But it's not.
No.
Okay, so that's really good to know. Now we have some mistakes that's very common when it comes to agreements.
Yeah, and how to avoid them.
Avoid them. And that's why we're having this episode, so you don't have to do the mistakes.
And this is not legal advice, knowledge sharing.
As always.
Always recommend check with your lawyer.
Always.
Always.
And remember to like and subscribe to our channel because we're sharing this valuable knowledge that you can use in your everyday business life. And it's here at Business Law Toolbox and it's at zero cost. Remember that.
Remember that.
Yes, and that's it for today. Thank you so much for sharing.
Thank you.
Until next time.
Hej då!
Hej då! Can a contract be so bad that the law laughs and just walks away?
Ouch.
Ouch. Today we're going to talk about something called Pactum Turpe.
A dirty agreement.
Ooh.
Dirty.
So, yeah, it sounds very crazy, but it's, existing.
It does. And it's more common and broader than you might think.
Wow.
So basically, the concept is that if an agreement revolves around something that is illegal or against public policy or moral even, the law will not enforce it.
Oh.
So the simple one is, of course, if you and I contract to murder someone.
Yeah.
And then you give me money and I skip the murdering part. And you want your monies back.
And I'll sue you for that?
Yeah. It will be, the court will say, we are not going to touch this agreement. You both deserve to be in jail for plotting for murder, right?
Oh, oopsie.
Yeah. But let's give some more...
yeah, let's break it down. So what actually make a contract illegal?
So, like I said, it's about contracting around something that is illegal. And the murder might be an obvious case, but we're going to give you 3 more nuanced cases that might surprise you.
Yeah.
Because they might be relevant for you even.
Yes.
So let's start with the influencer.
Yeah. So imagine a company pays an influencer $10,000 for a fake review post.
A fake review.
And then the post goes viral and the company don't want to pay the influencer.
So it's like it's a spa. The influencer rates the spa, describes how fantastic it is. The experience, but she never ever went, right?
Oh.
What happens?
Yeah, what happens in that case?
The court will say, this is fraud. This is not real. So she cannot claim to get the money.
Simple as that.
The law will not enforce that contract.
So
because what she did was illegal.
Yeah, so honesty is very important even by law.
Even by law, yeah, exactly. No, but fake review is not okay.
No. I think this one is quite common. I mean...
Yeah, and of course there's borderlines, but now we're talking about truly fake.
Yeah.
Like telling them how amazing it is, giving a review, saying that you can recommend it to everybody. Haven't even been there.
Oopsie-daisy. So imagine then if I would like a pay raise at the company I work with for like $20,000 a year or something.
Yeah.
And I tell my boss, if you don't give me that, I will tell all the company's dirty little secrets around the world.
Or even worse, you might tell about, what that boss did last Christmas party, right?
Oops, yeah, exactly that one.
Yeah. And again, that is blackmail.
Oh, we have an episode about that.
Yeah. So even if the boss says, okay, I'll give you the bonus. Next year, it's yours. And then the boss heads out of the company. So come next year, you show the bonus agreement, say, I want my bonus. Well, they can say, no, this is a dirty agreement. It's based on you blackmailing your former boss. Sorry.
It's illegal.
It's illegal.
Yeah, I mean, and then if Mr. Greedy calls me, let's say I'm an artist, and he calls me up and say, hey, girl, can you make a copy of Banksy? I mean, no one will notice, and I will auction it out next week. These people know nothing about art. So I make the copy, really good one, and after the auction, I hand it over before, but after the auction, I cannot get some contact with Mr. Greedy at all. And he promised me millions.
So he did not pay you 50%?
He did not pay me 50% because of the copy I did.
Again. Fraud. It's a Pactum Turpe.
Yeah.
Illegal agreement. Dirty agreement. No chance. The courts say, we do not want to help you out. We don't want to enforce this. So it's illegal. They will not touch it. So you cannot get any help with your claim.
I have to think about that behind bars then.
Yeah, exactly. Yep.
Ooh, that sounds crazy. So is there anything else we need to think of when it comes to illegal contracts?
Good question. I would say be mindful not calling everything, oh, sorry, can't enforce it, I'm walking away.
Yeah.
I mean, imagine that you're buying a house and you're helping with the moving or something, and part of that agreement is that you're going to drop off a sofa right next to the house.
Yeah.
And it might be illegal parking.
Oh.
I wouldn't say that the entire agreement is gone.
No, hopefully not.
No. So there can be nuances. And also, if you take a loan and the interest rate is too high, it can be usury.
Yeah, we also have an episode about that.
Yeah. But then the court might say that that part is illegal. So we'll take it down. The interest part will reduce the interest. But you still owe me the loan. So they might just adjust the agreement instead of just saying it's illegal, will not touch it.
Oh, okay.
So it's kind of a gliding scale. How bad is it?
How bad is it? That's really good to know. So now you know honesty is always the right way to go.
Yep. Better business.
Yeah, it is. Thank you so much for giving us this knowledge and advice. And remember to like and subscribe to our channel. It's very important if you want to navigate in the business world with power, with knowledge, and also have fun.
And this is not
legal advice. It's knowledge sharing as always on this channel. Thank you so much.
Thank you.
Hej då.
Hej då.
Are handshakes legally binding? Short answer, often yes, but you might have a lot of things to prove in that case. But that's why we have our business lawyer here today, because that's exactly what we're going to talk about and how you can do the Handshake Plus, which we're going to reveal today.
Hello.
So we're going to talk about it, and this is a question that I ask myself often. Are handshakes legally binding?
One of the most common questions I get, actually.
Really?
Yeah. So let's walk you through it.
Yes, so let's start.
Law school in 1 minute. What is an agreement?
Yeah.
Yeah. We have an offer.
Mm-hmm.
We have acceptance. And we have consideration. And we have meetings of the mind. What's missing?
Paper.
No paper. So offer, I offer to sell my car for $3,000 to you.
Yeah.
I offer something. Acceptance, you say, I'm happy to buy that car for that price. And consideration, that is that something has to be transferred of value. So in this case, car, cash.
Yeah.
Meetings of the mind, we intend to agree on this, to do a car sale.
Yep.
Yeah. Then we have an agreement. Oral, no written, no pen and paper.
Feels a bit risky.
Very, very, very risky, of course. And there are carve-outs, exceptions that you need to be aware of, where you have to have it in writing in order for it to be valid.
Okay, such as?
Such as a real estate, but that will depend which country you live in.
Oh.
Yeah. So different legal orders will have different type of agreements that need to be in writing. So you need to check that out.
Okay.
Yeah.
Really good. So you agreed to buy a food truck for $25,000. Shake hands. But after that, the seller says, we said $35,000. If all I have is a handshake, what do I have?
You have word against word. Suddenly you have a dispute. How are you going to prove that it was 25 when he claims 35, right?
Yeah.
So it might have been legally binding, but you end up in court.
And that's why it's so difficult with the handshake, because you need proof.
Yeah.
Well. So let's move forward.
Yeah. So just to be clear, an oral agreement can be binding. The problem is, of course, proof. If you claim that we have an agreement, you need to prove it. It's up to you.
Yeah.
Make it more likely than not. And there are carve-outs. Like we said, real estate is typical. Sometimes it can be assignment of intellectual property, like copyright in some jurisdictions.
Yeah.
Guarantees, where I say that if you cannot pay, I'll step in and pay for you. Might be.
Yeah.
So there are various situations. And in the US, there can also be that a transaction where the value is over $500 might be, so it needs to be in writing. There are some exceptions, but that's a general rule under their Sales of Goods Act. So you need to be mindful.
But that makes sense.
It does.
Yeah. So the real battlefield, burden of proof.
Exactly. So even if the agreement orally, verbally is binding, it's about proving it. And then we'll look for tangible evidence.
Yeah.
Do you have emails? Do you have can you show that you actually sent me some money or a text message? Anything that can prove that we had an agreement will help your case.
Yeah.
Yeah. Do I have any witnesses?
Oh, that's a good one.
Yeah. Conduct. The way we acted afterwards, does that indicate that we had an agreement?
Okay, I never thought about that.
Yeah. And of course, part performance. I mean, if I claim that we decided that I'm going to mow your lawn every Monday, and I did it for 3 Mondays, and I have witnesses, and I can show that you sent me money, that might be enough.
Okay.
Yeah.
Really good. So imagine like a pizza owner signs a deal with the local football team, and he says, free pizza for every win. And they win every time. And now the owner is like, but I only said the first win.
Trying to weasel out of it, right?
Yeah, but there is proof. I mean, DMs and such things. So how do you handle that situation?
Again, how do you prove it?
Yeah.
He might have just played nice for a while, but he said that I wouldn't do it every win.
And they win like 10 games in a row.
Yeah. So then that handshake can turn rather sour. But if you can prove that it was ongoingly that he did it every time they won, he might end up keep serving you that pizza.
Oh, so be careful if you promise something.
Yeah.
So handshake that bites businesses.
Yeah. So first of all, did it ever happen? I mean, the burden of proof.
Yeah.
Can I force you to pay me or to give me that car, right?
Yep, good to know.
Secondly, scope creep. Okay, we agreed that I'm going to help you out, mow your lawn every Monday.
Yeah.
But what if you claim that there's more to the story? I was also supposed to take out the trash, walk your dog.
Oh.
Right? How do you prove what was actually included and what was not included in that agreement?
Oh, that's a hard one.
Yeah, that's a really hard one.
Okay.
Price surprises.
Oh.
Was it a fixed price of $3,000 every month, or was that an estimate? Right?
Yeah.
Typical argument afterwards.
Yeah.
You need to pay me more. This is unreasonable. No way. Why should I? We agreed. So when you don't have any writing, there are so many areas where you just don't know. Really complex.
So how do you make handshakes more safe then?
Document as much as ever possible. If you need to move fast, if you need to act on that handshake without putting together a written agreement, send an email confirmation afterwards. That's so detailed. Thank you for the great meetings. I so look forward to delivering X to you within 3 weeks for the price of Y. Please confirm and ask for confirmation.
That's brilliant.
Please let me know if I missed anything. Otherwise, looking forward to this deal.
Simple as that.
Yeah.
Wow.
That's the handshake plus.
That's the handshake plus. And now you know about that. So write an email afterwards.
Yeah. Or something.
Yeah.
Yeah.
So the final take and the friendly disclaimer. This
is not legal advice. This is knowledge sharing. Always check your jurisdiction. What's really going on. Find a lawyer. That will help you.
Really good.
And do believe in a nice handshake when it's appropriate. I mean, you have to trust people as well.
But you can follow up by email.
Yeah, for sure.
For sure. So if this episode saved you from some headache, please like and subscribe to our channel. This is so valuable knowledge for you in your business life. That's it for today.
That's it.
Hej då!
Hej då!